what could go wrong, Melissa?
The landlord doesn't even know where the security deposit is.
Forget about where it is.
Yeah,
it's long gone.
They don't know the proper eviction process.
Yeah, God forbid they have to evict somebody, right?
We're talking about the delegation of power, the unauthorized practice of law. Another issue was commingling of funds, using client funds improperly. Very easy to do.
You enter into a contract to enter into a contract at closing. Like, we're gonna agree to perhaps agree in the future. We have like crazy people who are alcoholics and they just want their commission or whatever. Come on, realtors. I mean nothing by it, but you guys are wild. Okay, let's be honest. You guys are wild. Welcome to the Miami Common Law Podcast, where we discuss business law and litigation as seen through Miami's entrepreneurial and cultural lens. I'm Jesus La Rosa, a Florida licensed attorney and the host of the Miami Common Law Podcast. Although this show is hosted by my law firm, La Rosa Law PA, it is not part of my legal practice. It is, however, my effort to have some fun, nerd out with my peers, and share zero-cost insights and entertainment for Miami's entrepreneurs and legal community. Our goal is to help business owners avoid mistakes and to create value for lawyers and clients alike. All right, guys, a little housekeeping. If you've not signed a contract with my firm, I'm not your lawyer. Also, laws change and jurisdictions differ. So if you've got any questions about anything we've said here today, please call a lawyer in your area. All right, with that, we'll get started. Ahora sí, cheers.
Okay.
Thank you for coming back on. Just, injecting that little bit of fun, getting out of the desk, right? Getting out of the desk a little bit, enjoying, nerding out.
Yeah.
That's what it's about.
Yeah.
That's what it's about, right? Having one day of the month at least that we get away from the matters, we get away from the exam prep, we get exam from the...
I'm a celebrity now. All my friends have seen the podcast and I'm basically famous.
No way. Tell me more.
Yeah. My friends are like, you came up on my For You page. And I'm like, good. That means the money's being put to good use.
Oh my God, the marketing dollars are working.
Yes,
Thank
are.
God.
Yes,
Nice. Well, at least we're getting exposure a little bit. I think that is what the team is trying to do. So that's amazing. I'm glad that that's the case. Tell me a little bit about what have you been up to? I know that we had the little break. I know you just started second year?
Well, this is the second semester of the second year.
Okay, that's right. So you're over the peak, over 50% now.
Yeah, I don't know how to explain it.
Technically.
I'm like starting to feel better, starting to feel like I have a better grip at like doing everything I need to do.
Okay.
Because I feel like before 2L is harder than 1L because you're just trying to
for sure
to like find a way to do everything now. Because before 1L was just focusing on passing and doing school stuff. Now it's work, other commitments, you have to put your time into different places.
Right. So thinking about a life beyond law school.
Yeah, I've been really enjoying it. I mean, I've been enjoying doing more deliverables.
Nice.
Dealing with my imposter syndrome, which I think is so problematic, and I had no idea how bad it really was.
I appreciate your candor regarding that. Look, we all have it. You know what I mean? And opposing counsel is gonna lean on that. Some Lord knows some guys will tell me how long they've been practicing. You know what I mean? To try to pull at those heartstrings. But don't worry about it. It comes, like I said, it comes with the reps. So no worries. But how about that feeling like that? I remember when I was halfway through, I was like, I can't believe I'm only halfway through. You know what I mean? Are you getting that too? Or is it feeling like you're on the downward slope?
For me, it's more like, I can't believe I'm in my second semester. I can't believe that like I've even made it this far, this fast. I feel like just yesterday I had, made my friends in law school and I was stressed about my first finals. And now I'm like.
Amazing.
They're like, whatever. I'm tired. Don't get me wrong.
Right.
Again, having all these other commitments and everything, it's exhausting, but it's like empowering at the same time because you're like, wow, I'm capable of doing all these things. So,
that's amazing. That's good to hear.
Yeah. So I'm having a pretty good time.
That's awesome. I remember the second semester of the second year. You know what made it kind of unpleasant for me was journal. As much as I think it leveled me up, it was proper hazing. I love, I lean into the friction, but it was like, oh man, those authority checks sucked.
My friend is in law review and she's like, they gave me back my paper and they just like destroyed me. And I'm like,
the number of hours that went in, like I remember drafting my journal note. It would have been the second semester. And I didn't go to class a whole week. Because you know how it is. You're always like doing the reading right before class, or you know what I mean. You're just like, just getting your head out of water, you know.
Yeah.
And then you throw on top of that, like, oh, write me like a 40-pager on some circuit split before ChatGPT and Lexus AI. And you're like, I guess I'm not going to class this week, bro. You know what I mean?
I mean, I'm pretty naughty when it comes to having to read all my cases and prepare for class.
Sure. Nice.
I always tell I'm an ASP fellow. So I tell all my students, I'm like, don't lead by my example. Go to office hours.
Sure.
Read.
Sure. What does that mean, ASP fellow? What is that?
It's an academic success program.
Oh.
So it's the people
how fancy. Okay.
It's the people that excelled their first year, and then they help the new class of one else.
Oh my God, Danielle, did you hear that flex? She excelled her first year, bro. Get out of here. I had to involve the producer on that one. I love the subtle flex. I love that for you, Melissa. That's great.
It is.
No. Tell me. So you're like a peer mentor type of thing, like hey, you know, do me, and you tell them like, hey, don't do what I say, not what I do.
Yes.
Got it. It doesn't always work out.
You know, everyone learns different, and some people need to try everything first before they can decide what they don't have to do. I found out that reading was not helping me.
Sure.
And it was just adding stress to my life. So I decided if I can do this without the extra reading and torment,
right,
then I'm going to do it. I'm going to cut the corners that I know I can cut without it affecting me.
That's true mastery, right? Like choosing what matters to you. And I think, as you know, Evelyn and Jessica and I, and you're invited, I'm kind of like helping them prep for the bar and stuff. And it's amazing to me how many people forget that again when it comes to bar prep, because there's all these cookie cutter courses like Barbary and Themis or whatever, and they just want you to do these like crazy outlines and watch these crazy videos. And people forget like how they learn, which for me is just recall. It's just repetitions. It's like, how many questions did I do? How many times did I have to find that factoid and apply it? And so in retrospect, if I could have like outlined less and done just a lot more practice questions for any given exam, so for like contracts or con law or torts or whatever, if I did just a bunch of MBE questions in preparation for the final exam for the class, I probably would have done even better.
I find that outlining is just like, I do it one and done to, synthesize the information.
Right.
But if you ask me how many times I actually look back at my outline and study from my outline, absolutely not. I Quizlet, I make flashcards. It's the same thing,
Exactly.
Testing each other, doing multiple choice of any multiple choice that I can find, anything that I can have chat make me is what I'm going to do. Like essays, drills, that's
Have you had any open book tests?
Yes.
Okay.
My sales class.
Do you stress more about the outline on those because you like think you're gonna actually use it as a tool on test day?
My open book exam was just the statute book for sales.
Okay.
UCC Article 2.
Okay, lovely.
Battle of the Forms.
I'm getting PTSD.
Me too.
Yeah, it's okay. It's fine. We'll get right over it.
So all the notes were in the book. And I found that while I was taking the exam, from writing in the book and doing the multiple choice questions, so much flipping through the book, I barely even needed the book during the exam.
Nice.
It was just like if I wanted to use specific language for the essay that I wanted to be, pretty and perfect.
Right.
Or if I just wanted to make sure that I was 100% about the rule I was applying. But I don't like open book because if it's essay format only, it's really going to get into the nitty gritty, who writes better and who just makes it prettier at that point, because all the information is there for you. So there's really no reason for you to like.
I hated open book.
Yeah, that's not my favorite.
I didn't like it because it made it so that I typically phoned it in. In other words, I relied on the fact that it was open book and I didn't do the reps. Do you know what I mean?
Yeah,
and so then I just showed up to the test with like a library of crap and like nothing loaded in. You know what I mean? And so in retrospect, the tests that were open book were the ones that I performed least well in. Because I showed up least prepared.
It's application. It's
right.
Really knowing it, because those multiple choice questions that I don't know how these professors write their multiple choice questions in their essays. I don't know if they sit there in their house like laughing at like the pain that they're about to put their students in, because they're never like the MBE questions. They're never like Quimby. They're nothing like that. They are
You talking about the essay questions?
like the essay questions that the professors make, and some professors make their own multiple choice questions.
Okay.
I've had a professor give me multiple choice that's like A through like F.
Oh my God.
What do you mean A through F?
That's funny.
And it's like
They
choices,
have
and then
the alphabet.
it's like A and B, B but not C,
Wow.
C and D. And I'm like, and then it says all of the above, and then you rethink your entire life, and I'm like,
Damn.
I don't really know.
I forgot. You know, I didn't have a lot of multiple choice tests in law school. Maybe torts. I think torts, but I did so many MBA prep questions I could just like anticipate what the answer was. But yeah, back then it was like a genuine like, damn, how are you guys doing this? But now I'm sure they're all using ChatGPT to draft their own exams.
Not the older ones.
You don't think so?
The older ones get pleasure from sitting there and
Really?
writing there. Yeah.
Sadicos, bro.
The older ones. And the younger ones definitely, that's why we have more multiple choice nowadays, is because you know, now they give us 3 hours for the exam. They don't want to give you a full like essay or multiple essays, because then it's gonna be sloppy, because you're fighting against the clock.
Right.
But either way,
it's easier to grade multiple choice.
You know,
that's the thing. Those essays are a pain to read and
in my
grade.
School, only 2 weeks, I think, or 10 days to grade.
Oh, wow.
Some teachers have multiple sections, multiple classes. Imagine essays.
Sure.
Essays.
Sure.
It's, I guess, our way of giving back to them after they put us through misery is having to read our essays.
Yeah, I recall them coming in always with the like evaluation, you know, the teacher evaluations, like in advance, like well in advance of finals prep. You know what I mean? Like, hey guys, it's time to tell us how good we did before you hate me.
Yeah.
I remember that.
Yeah.
All right, well look, let's zero in. Let's lock in on today's topic. Okay, it's something that we alluded to it in an earlier podcast, the one that I did with Cindy, which we did about real estate. We kind of have a round 2 today planned about real estate, and it's really around this issue that we deal a lot with, which is taking care of our landlords. We have a lot of clients who are landlords, or they're litigating agreements with their tenants, you know, lease agreements. And after doing this for a while, it felt like, wow, there's a real market need here, right? Because a lot of the clients were frankly just getting in trouble in super avoidable ways, right? So they were relying on either the real estate agent or property manager, typically the person that they're relying on to find the tenant, to just do everything, you know, to draft the lease agreement, and they can only do forms, and then to negotiate the rent. And then if any issue pops up, as it always does, because no one's perfect, right? Like things break, right? Like electrical equipment breaks, and who's responsible for what, and then there's not really like a clear guidance from my property managers and from my realtors about what is a security deposit and what's the right way to do that. And like, no, it's not your cash. It's supposed to be in a different account, and all of these things. So tell me a little bit about I know that you drafted a hell of an article. I love the article, by the way. You did a great job on that. But tell me a little bit about the experience just drafting the article, kind of what you learned. I'll talk a little bit more about the practical things and how the issues come up and kind of what it's meant to solve. But just as you were drafting the article, what were your thoughts? What were the things that you were?
I struggled as much as what I expect the property manager to struggle when they're trying to decide what to do next.
Okay.
Just because, since it is such a practical thing, the case law on it is a little older. You know, there aren't as much recent cases because of the way that they deal with it. And I was just really nervous. I was like, where do I begin?
It's a little archaic.
Yes.
Sure.
But it all boils down to unauthorized practice of law, which is something that, you know, you don't want to be suits. You don't want to find yourself in a suits situation where you're not an attorney and you're using your discretion. You're trying to apply something that you don't have the ability to, that you're not you can't enforce this, you can't defend this, you can't really do much. So, when we're talking about escrow, you know, it's what you're saying. The landlord thinks that they can just get that check and put it into their account, but they can't. They have to put it separately. There can't be commingling of funds. There can't be anything like that.
Just as a side note, sorry to interrupt, but isn't it how interesting, like how realtors and real estate agents, they feel to me like the true contract warriors, right? They're in the streets with contracts. Like lawyers, like we're kind of like philosophers about it, and contractual interpretation, and it's very like ivory tower, and we know all these things about all these clauses, but they're like the hood rats of contracts, right? Because they don't. First of all, they know what nothing means. They use some standard form that somebody drafted a long time ago, and they can't change it. They can't explain it to them. Have some program that has like little drop downs, and then just like plug them in, and then the program just spits out whatever. And meanwhile, they're turning around billions of dollars of real estate every year using these forms, negotiating contracts, being like super savage about it, right? Like the negotiation tactics that I've seen here in South Florida have been like insane. And there's always like, a real estate contract as a whole, just like taking a step back, it's kind of a beast, right? Typical contracts like the one you and I signed when you joined the firm, they're a one-time thing, right? They're like, whatever the agreement is, here it is, here are the stipulations, you sign, I sign, cool, we're off into the races, right? But real estate contracts are these beasts that are to be executed over a 30 to 60 to 90-day period. And so you enter into a contract to enter into a contract at closing, right? Which is like a very interesting idea in and of itself. Like we're going to agree to perhaps agree in the future. Like that we're kind of interested in doing this. And by the way, we have like crazy people who are alcoholics and they just want their commission or whatever. Look, come on, realtors. I mean nothing by it, but you guys are wild. Okay, let's be honest. You guys are wild.
Yeah.
You have these people spearheading this relationship between these parties that either want to sell or buy or whatever, and they enter into this agreement, and then there's like checkpoints, right? There's like all right, I'm going to give you $10,000 so that you can accept my offer to maybe buy your house in 60 days. And you're like, no, I want $20,000 because I don't trust you. You look funny, right? You're like, I want higher earnest money.
You look broke.
Right. And there's a lot that goes into that. Like why ask for a higher earnest money amount, right? And does the contract break down there? And then there's like the inspection period, right? You have so much time to go and conduct an inspection of the property. Then you have a fight over what the inspection finds.
And you always find something in those inspections.
You always find something. If you have a good inspector, trust me, where you look, you find, right? And then you have to have a discussion about like, no, you got to fix this and you got to fix that and da-da-da-da-da. And no, you got to fix it by this day. And or no, I'm going to deduct it from the price of the thing. And then all of a sudden we're amending a contract that's not been drafted yet. So these things are behemoths.
Yeah, and
Let's take a moment to appreciate that.
I think that the issue too is what you're saying. Like they don't know what the contract even says.
No one reads it.
They're just signing documents.
People are just having Cuban conversations on the side. They're using some template. They're filling in lines, and no one's read the damn thing.
And then they're unhappy with the clauses and the situations they find themselves in, but they signed it. These cookie cutter contracts, you can't edit them. So you're trying to have a property manager or real estate agent, amend something or draft something that they are not authorized to draft.
Right. They would get in trouble if the Florida bar found out.
Exactly. So it's like all things in life. You need to do things the right way because if not, everything crumbles.
100%. 100%. So then that was a little bit of a tangent, but just a moment of appreciation for how complicated these real estate transactions are, because I've used now a similar model in when we buy or sell, like in our acquisitions of businesses, right? There's brokers that buy and sell businesses, or that help people buy and sell businesses, and because they make a commission, it's all about let's just get in here. Let's do the sale. No inspection, no due diligence, no fair market value valuation. Let's just do it like a regular, you sign here, I sign here, give me the money, whatever.
Yeah, as is, just.
Right. And my whole thing is like, look, this should be a lot like real estate. Like you're buying something that's potentially a couple $100,000. Let's enter into a contract to then close at a later date. Let's run a proper valuation of the company. Let's ask for books. Let's see where the skeletons are. Because if you've ran a business for long enough and you know enough business owners and you've represented enough business owners, you know every business has skeletons somewhere. And so let's find those and let's price them accordingly. And so I've taken sort of a page out of the sort of the real estate playbook and I've applied it to business transactions. But going back to property managers and our topic for today, which is typically the relationship between the landlord and the tenant. It seems like a fairly simple relationship.
It seems.
It seems like what's there to haggle over? You give me the first month and you give me a deposit and I put it away and you pay me rent. And if you don't pay me rent, I kick you out.
Mm-hmm.
What could go wrong, Melissa? What could go wrong? Tell me, what goes wrong typically sometimes?
They want their security deposit back and then they're not entitled to it, or they are entitled to it and the landlord thinks they're not entitled to it. There's a time frame for these things. The escrow, the security deposit, the landlord doesn't even know where the security deposit is.
Forget about where it is.
Yeah,
it's long gone. Forget about a notice.
Yeah.
Right?
So they don't know the proper eviction process.
Yeah, God forbid they have to evict somebody, right?
Mm-hmm. Imagine they're just telling their tenant, this is what's going to happen.
Mm-hmm.
But they don't know who they have in their, who their tenant is. Their tenant can be an attorney. It could be someone who's friends with an attorney. It could be someone who's just a little smart.
Right.
Just a little bit. And decides, you know what? Let me see what my contract says.
Exactly. But let's stop right there at the eviction phase, right? So let's say you're not a big landlord, right? You don't have 100 units, right? You have 1 unit. You have 2 units, okay? And with the interest rates the way they are right now, you're not making a bunch of money on your unit month to month, right? You're, paying your mortgage, right? You're not rich. And so you've not hired counsel, right? You didn't call La Rosala and get outside general counsel for landlords because you said, why should I do that?
Let's not even know it exists.
Let's wait until there's a problem that we have to pay a lawyer for, right? Okay, so you did that. And then the tenant decided to stop paying the rent because whatever. They have personal problems, but they're not leaving, right? Cue the Wolf of Wall Street. I am leaving, right? They're not leaving, right? So they're going to need a wrecking ball to get them out of there. Okay. So then you call us, right? You call us and you're like, dude, I got a problem. We got to evict this guy, whatever. We feel bad about it, but we got to turn the apartment over. All of a sudden, because you didn't hire us before and we didn't handle the process and we haven't been collecting rent and we're not plugged in, we have to do a lot of heavy lifting. We have to review a lot of stuff. We got to make filings and stuff like that. And so now all of a sudden, you're looking at potentially spending 2, 3, 4 months rent on a retainer agreement to put in an escrow so that we can litigate your eviction to maybe get rid of this person 1 or 2 months into the future, right? Whereas, and this is a really good highlight of what outside general counsel for landlords does, if we're already retained from the beginning, it's all baked into the contract. Obviously, we'll speak about the details of how that offer works. I'm not going to get into the specifics, but the upshot is we're comparable to a property manager, right? So we make it so that at the end of the day, it's about the same cost. And when the proverbial shit hits the fan, we're already plugged in, right? We're ready to go.
Yeah, I think that not only that, but we're like a general contractor too, because something breaks, you can call us and we find the adequate person to bring into your home instead of like, oh shit, like something broke, I need to call whoever to come into my house, and then you're just welcoming more liability and more issues with that.
That's a great point, which is set it and forget it, right? We have an operations specialist, in-house that goes to the property every so often, every couple months, the way that you set it up, our landlords decide to do it. And they're keeping an eye on things. They're keeping communications clear with the tenants, right? So you're not chatting on WhatsApp, you're not chatting on this and that. there's a clear buffer between the client and counsel. So it's counsel speaking to your tenant, you know, in a legal capacity. So there's not arguments about you said, you know, oh, I'm going to call my lawyer. It's like, guess what? You're already talking to my lawyer. You know what I mean? So it changes the dynamics of the relationship completely. And in my experience, it's avoided a ton of issues. At least the tenants that we've dealt with so far have been very cooperative. And I suspect they've avoided, you know, a lot of issues for the landlords that we've represented so far. So that's exciting. And yeah, go ahead. Sorry, I interrupted.
I also think that having counsel is helpful because you could still have your property manager, but you know, your counsel will train your property manager so that they know their limits, because the problem here is that they don't even know what they can and can't do, you know?
Right.
They don't know when they're using legal judgment, and that's what creates the fiduciary duty that they're not supposed to have with the tenant.
That's a good point, which is that it's not always mutually exclusive, right? So we've positioned the idea like, look, in essence, what is the property manager doing? A lot of them are just getting the tenant, you know, and they're not doing much other than that. I guess there's some really high-end ones that are doing a lot of maintenance, and they're dealing with, and that's like a totally different thing. But yeah, they definitely, in no time should they be handling communications, modifying agreements, right? Strategizing, like, what are you liable for? What am I liable for? Things break, right? What's regular where? What's, you punched a hole through my wall, right? I say that and it's funny, but a lot of the things that actually happen are in some gray area in between, right? And if you don't have somebody who is keeping the definitions clear and calling balls and strikes as issues arise, what happens is these problems fester, and then at the end of the lease, it's multi-$1,000 issues that have festered over the course of many years, and then it's a real problem.
Yeah.
Right. Cool.
Yeah, I mean, I think the point here is that the main thing that I saw when I was researching was avoiding unauthorized practice of law. That's the main thing the courts are trying to avoid.
Mm-hmm.
If we're talking in like a more legal context, not so practical, that's what the court is, like the policy reasoning behind it is because they don't want the fiduciary duty to fall in the hands of somebody that is not able to protect it, doesn't know how to go about it.
Absolutely.
And
then we alluded to this already, but the deposit, like our landlords never get the deposit, right? So that's not cash flow that they're considering to be, that could get lost, right? The money gets paid to us, to our escrow account.
A proper IOTA.
A proper IOTA, and that deposit is there should it ever be used. And in addition to that, the tenants pay us the rent, and we forward it over to the landlords. So I just want to make that point of clarification briefly. And then you were saying?
I was saying that then the landlords or the property manager will say, oh, we have insurance, you know, like we're protected from this little tiny mistake that we made. But a lot of these insurances and these E&O policies and stuff, they're not going to protect you when it comes to this type of situation, because what they protect doesn't really focus on
right. So the scope of the policies of the property managers don't cover the errors and omissions that ours do, right? Yeah. The sort of the communications, the misunderstandings, the things that end up in litigation, right? You end up litigating with a tenant, your property manager's insurance cover isn't going to cover that. I mean, it's not going to cover us either, but it's not really helpful.
And the problem is that if they were to, for whatever reason, want to cover you, they usually have like a notice policy where you have to tell them as soon as possible or within a certain time. And that's the problem. You don't even know that you're doing something wrong.
Right.
Which takes us back even to our construction podcast about the subcontractors.
Mm-hmm.
You know, not knowing, not being aware is just never enough.
Right.
So you can't fall back on, oh, I have insurance, I have errors and omissions, it'll protect me. In this situation, it's not.
And off of that point on contractors, one little secret that people don't know about is that a lot of property managers make a percentage on what the contractors is billing them. So they get, whatever they're managing all these many properties. They have a couple of contractors they're working with. And what the landlords don't know is that they're quoting 20, sometimes 30% above what the landlord is actually being paid, because they're basically getting paid a referral fee, right? Which is something that obviously we don't handle and don't do.
I think it's a very sneaky world, that realm of like landlord and subcontracting that work and delegating this power. I think that when you work with an attorney, we have a duty of like honesty, of doing things the right way. You can feel safe and confident that things are going as they should be, that if something happens, we can handle it, and that nothing sneaky. Should be a good, reputable attorney. Jesus la rosa.
Dude, it's funny. As I was thinking about this episode, I was like wanting it to not read like an ad, but I mean, you can't avoid it, right? I think your article does a great job of just informing.
Yes.
And obviously we're selling the service, and I think there's no shame in that.
But it's just so true.
Right. I mean, we really believe it, right?
Yeah,
it's not like
I didn't even realize how important it was as I was doing the article, and I saw how many things could go wrong. And I told my in-laws, I was like, do you guys have attorneys for this?
That's pretty wild, right?
Because yeah. And the more properties you have, the more tenants that are under you. It just takes one tenant to ruin your life.
Right. And another issue is the issue of privilege, right? So anything that that you're telling your property manager, that you're telling a realtor, they're potentially a witness that can be subpoenaed, right? So like if you have an issue with your tenant, they had a discussion with fulanito, and all of a sudden they're being subpoenaed for a deposition, right? Whereas anything the clients tell us is privileged.
Yeah.
Right? So it's like, can't do that.
It's just, I think people just think that it's out of their budget or not worth it or whatever, but it ends up quadrupling, honestly.
Right. Lo barato sale caro, they say.
Yeah.
Okay. All right, cool. So I don't want to belabor the point. I think that we've done a pretty good job at selling the service. I think your article speaks for itself, and I'm happy with that. I think we can leave that there, and we can move on to our next most favorite segment, Sazón Completo.
Yes.
Right? Okay, cool. Let's do it. Let's do a little Sazón Completo. So what do we want to start with? Do we want to start with the case? Do we want to do disciplinary actions? Do we even have an AI update on here?
No.
Okay.
But
all right, what do we want to do?
For the Florida disciplinary.
Ooh, okay. Let's do it with the achievement first.
I say we do that one first just because it ties in.
Sure. Let's do it. Let's do it.
So this one's based off of, this last month and everything, and it's going...
Month of January. Okay.
Yes.
Of 26. All
it's going back to exactly what we're talking about. I love when that happens. I love when everything just starts to connect
There's
to
themes.
each other.
There's themes.
Like, how did they know I was
the
writing
stars
this
align.
article?
Exactly. You see it everywhere.
So again, we're talking about the delegation of power and the unauthorized practice of law.
Right.
You cannot have your legal assistant or fulanito be doing anything other than getting information and putting it onto a piece of paper that all they're doing is just writing down what the client told them. They're not supposed to be using legal judgment, strategizing, any of that. That was one of the issues that was found here, was failure to supervise. Another issue was the same commingling of funds, using client funds improperly. Very easy to do if you're not aware of these things, or if you have somebody else handling your IOTA account, and you're just not keeping up to tabs. So I thought that those two things were the main things that really stood out to me for today's podcast, in, considering our landlord issues. And
yeah, and look, I love that. And it's true. This is a recurring theme. I think, I mean, I've said it before, but the number one way people get in trouble, attorneys get in trouble, even well-meaning attorneys get in trouble, is mismanaging client funds. And so when you're doing something like outside general counsel for landlords, you're holding multiple escrow accounts. That stuff is really important, and it goes to trust. And then when you're delegating responsibilities that only you can do.
Which ties back to the fact that the landlord will think, "Oh, that wasn't my fault. It was my property manager's fault. That's their problem to deal with. They'll get sued."
Right.
No, you're gonna get sued because that's the connection here. Just like the attorney
Exactly.
is gonna get in trouble for whatever their assistant does or whatever another person in the firm does that it might not even be related to them, but just because it's under their
The
umbrella.
baton stops with me.
Yeah.
And as a general rule, you want to have somebody who's got skin in the game, somebody that's got something to lose, because they're not just looking over your interest, they're looking after their own interest, right? Because, I mean, at least anytime I have a fee dispute with a client, not that those happen often or anything, but, sometimes, like a restaurant, hey, you charged me for this. I think you double charged, whatever. That happens. Mistakes happen. Again, not often, but there's always a communication that you need to have with your client. And I'm always running this hypo in my head, which is like, if I have to stand up before the Florida Supreme Court and explain myself as to why X, Y, and Z happened and not the other thing, is my course of action such that I would have no problem doing that? That's kind of like my North Star when it comes to these type of fee disputes. And as you know, the overwhelming majority of the time, just because I know that we're in a customer-facing industry, it's like, give the discount, waive the fee. Like, it's never, it typically is not worth litigating with your client. You know what I mean? Because it's like a bad review. Who wants a bad review? That's like permanent.
It's an ick.
It's not only an ick, it's just like the cost of a bad review is like unquantifiable, right? Because it's just like, it's a stain on your reputation into infinity.
Yeah, and I think consumers, that weighs a lot for them because they're relating to another consumer and they're like, what's the worst thing that can happen to me? And then they see that and they're like, I don't know if I'm okay with that being the worst thing that can happen to me.
So the customer is always right. Even if they're not, they are, because at the end of the day, it's always going to be cheaper to pay a fixed cost now to positively resolve an issue that's going to fix litigation on the road. It's not going to come to an issue with the Florida bar, and it's going to keep your public-facing reputation. It's like, I mean, as attorneys, you know how important the reputation is. So you've seen me settle stuff with clients, more than I would like to, but sometimes it happens. You have disputes or whatever, and you have to, I'm like pretty abundant with and generous with like, hey, you know what? Let's call it cool. I'm going to give you a discount for this, that, or the other thing.
That was actually another one of the problems in this month's disciplinary, was that one of the attorneys didn't advise their client about an offer or something that came on the table.
Ooh,
and
that's spicy.
Yeah.
Yeah, you got to communicate, right? At the end of the day, it's their choice.
That, and then, the usual stuff of not filing the proper notice and not doing the administrative stuff. That was another issue.
There's a lot of people just like,
it's crazy,
falling off the wagon, having like a midlife crisis. There's a lot of this, like, you can tell someone's struggling. They're just like, because they're struggling, like everything around them is crazy. So their representation becomes crazy. But it almost like, it makes me feel bad when I read these disciplinary actions where it's like, had 13 cases where he didn't file pleadings and he didn't respond to the client and there was no update. And it's like, there's something going on there.
Yeah.
Right? But it doesn't matter, because at the end of the day, you're a professional.
Yeah.
So you can't tell the court, like, my mom died and I was depressed, and do you know what I mean? You can, if you do it, ahead of time enough, and you get ahead of the issue and like, look, I'm not in a place where I can practice, and you tell the client, hey, here's such and such that I think would do a good job, and substitutive counsel, but you have to be proactive about these issues and not let them fester, or else you end up on the monthly chief may.
Hey, with great power comes great responsibility.
That's right.
Okay?
100%.
So if we can't be held accountable, we were educated. We were told how to do this. I mean, as a law student, even before I got into law school and people were preparing me for law school, the fear they gave me about the bar and doing everything right and being honest and communication and honesty is key. When it boils down to everything, it's communication and candor. That's the main thing that
100%.
Goes
a long way. And people don't want to hear, just like they don't want to hear from their surgeon, hey, I'm having trouble at home. It's like,
you're not at home, buddy.
Brother, you're not operating today. Right?
Yeah.
Like, exactly. So, okay, I think that we've got a good handle on that. Today we've got, though, a little bit of a media case. We've got a little hometown press, a little lovey-dovey little case called the Biscayne 21 condominium case.
Yes.
Okay, that's not the actual caption of the case. The actual caption of the case is, and I've got the order here. Let's see. The lower court case is Angelica Avila et al. Versus Biscayne 21 Condominium Inc. et al.
Yes, et al. Because it's including also
And this
don't
one is
remember the name, but I think it's like BR or
TRD something.
Yeah.
Yeah. So this one's a doozy, right? This one actually got some media attention. Ended up on the
Reels,
socials, on the news. Do you want to lay up kind of the facts for me, just because I'll get into the weeds. I'll get into like the procedure weeds, but why don't you do the facts? Tell us the facts, Melissa.
Okay, don't cold call me. Okay, there's a light shining in my face right now. It makes me a little nervous.
You'll be okay. It's okay. I'm here to hold your hand. No worries.
No, but so Angelica, I think you said was the name, is only one of, I think it's 7 or 10. I think it was 10 the last time I checked. Tenants that are fighting because
owners. They own their
owners,
condos.
They own their condo.
In a big building. Mm-hmm.
Yes.
Okay.
And then a company came, a developer came to do
big angry developer in Miami. Oh, what a surprise, right? They're like, oh, we have an idea for this building right here from the 1970s.
Building, let's get rid of it and let's divide and conquer. So they bought, I think, maybe about like 80 or 90% of the apartments, and then
not cheap.
These last 7 to 10.
How many million
owners.
Do you think the developer spent on all the? How many melones do you think they put down on what they thought was gonna be their new skyscraper?
Dude,
what do you think? Like 100 million?
A house in Kendall right now is $1 million.
Right.
Imagine.
So figure they spent 150 melones, right, on units, okay?
On units.
To get their super majority that they wanted. Okay. So sorry, I'm going to keep interrupting you sometimes every now and again. So they went in, they bought a bunch of units, right? But not all.
No, not those.
Because you got some.
That's crazy.
I ain't going nowhere,
that
people.
That is crazy. Yeah. The people, I have so much, I'm so proud, like, to know that there are people that are like that. Their money is no object to them. They're like, no, thank you. I'm
this
not
is where
interested.
I want to retire. Yeah. This is where I want to live. So Angelica would have been in this minority.
Yes.
Okay. Sorry to single you out, Angelica. You're just the named plaintiff here. So.
Basically they bought it. They wanted to use their majority to decide to, get rid of, start destroying, because that's what we saw a video. We saw a video of what that looks like.
It's a little wild.
The zombie building right now.
It's a little wild. It's got graffiti. It's got open windows, palomillas.
I don't know how
crazy.
the 10 people are living there.
Right.
It's kind of scary.
It's dilapidated. Does the elevator work? I don't think the elevator works.
God, I hope they're on floor 3 max.
It seems like a problem, right? Yeah. Okay. Go ahead.
So they went in there and they started working. They started taking out permits. And then they, got sued. They asked for them to do an injunction.
Okay. Let's slow down. When you say they,
the owners of the 10 owners.
Okay. The 10 or so minority owners. So the developer came in. They bought a bunch of units. They changed the declaration, right? Because the declaration of the condominium had been drafted like in the 1970s when the statute was a certain way. So they came in with a certain playbook, right? They came in with a playbook, which is you come in, you buy, you change the declaration, and then you do whatever the hell you want, right? Because the original declaration had a minority protection, right? It said that, look, you need unanimity to change voting rights, right? But they came in and they changed all that, and they didn't need all that. They went ahead, they changed it, they terminated the condo, right? So that they could basically force these people out, right? These 10 people out, right?
Yeah, but the thing is that they could have changed a lot about that declaration, but when it came to the voting rights, they were not able to. But
we'll get there. We'll get there.
I get excited.
Yeah, I know. Punchline Melissa over here. I love that. Okay, so they came in. They did what they did. They've been at this for years. They exerted their efforts. Those hard-headed owners wouldn't leave, and then came the litigation,
Yes.
right? So I forget who actually. It must have been, I guess the plaintiffs in the lower court were the tenants, but I guess the play was they saw the writing on the wall, we're getting ousted, and they sued for protection, right? To
An
protect,
injunction to stop everything, you know.
right? To say, look, even though we're the minority, it was unanimous required to change the declaration and change everything else. And what happened? What did the lower court decide? What did the lower court decide on?
They actually,
The order was entered into on November 28th, 2023. Imagine, this has been going on for a little minute. For a minute. What did they decide?
So they decided in favor of the developers, big angry developers. They said that they could, in fact, change the language and that it, did create that majority, minority, and that they were right, that they could continue.
And this was Honorable Thomas J. Rabul. And, as I read this order, I thought it was well reasoned. I mean, I think, within at least, I think what he was going for was correct. And I think when a lot of people talk about this case, and I've seen it a lot on Instagram, they fail to mention a very important case that this whole thing is based on, which is this Kaufman case. This Kaufman case. They keep saying this is a 1970s case that had nothing to do with condos, well, I guess loosely, and it wasn't about termination, and it wasn't about voting rights, but it's this distinction about what can you do to condo declarations? What can the parties agree to? What can the parties agree to? And it turns out that the older Florida statute was more basic. It was not as sophisticated as the current statutes are with regard to condo associations. And so the older declarations didn't have as many, let's say, loopholes or abilities to do amendments. And so there was a more strict textualist interpretation. But in the Kaufman case, there was a provision in the declaration that said the earlier statute applies as amended from time to time, right? And so what the Kaufman court decided was that the parties could agree to this agreement, which is based on this statute at that time, but also as amended in the future. Not as amended today, the amendment that's currently exists, but as amended and forward into the future. So if the Florida legislature changes it to make it more pro-developer, then you've already agreed in writing to do that. Okay. And a little quiz, do you know how the declaration read in this case?
As is, not as amended.
So the declaration actually said as amended,
Right.
but no, it's okay. It's fine. It's fine. But it did not, this is a very interesting point. It did not say as amended from time to time. So there was one point there. So I think, but actually the lower court and the appellate court, the third DCA, agreed that the Kaufman language was not as muscular. All right, because it wasn't from time to time. It was as amended before. Nevertheless, though, the reasoning was more about this issue of voting rights, because the lower court, the decision says, look, there's no Kaufman language, okay, but we're gonna allow it as it pertains to the declaration, basically for other reasons. And what the court relied on was that it wouldn't change the voting language, right? So there could be a small amendment, because it wouldn't change the voting rights, because the lower court said, look, one unit is one vote. One unit is one vote. And, even though it doesn't have beefy Kaufman language, it has some Kaufman language, and they came in with a supermajority. And so, you know what? Because it doesn't change the voting rights, even though it doesn't have Kaufman language, we're going to allow it. Okay. And so then the third district saw that, and that was a very textualist, that was actually a very conservative approach from this court. And it said, look, we're going to we're going to interpret the language of the agreement exactly as it is, 1 unit, 1 vote. And the declaration, the new declaration, doesn't seek to change the definition of a vote, right? So it's not changing the scope of what a vote means. It's still 1 unit, 1 vote. It's just changing other things. And so we're going to allow it. So it went up on appeal. And actually the third DCA agreed about the Kaufman point, right? They said, look, it's not super beefy. But they disagreed about whether in reality the voting rights changed, right? Because if you have a unanimity requirement in the original declaration in order to terminate the condominium association, then if in the future that declaration is amended to not require unanimity, then what you've done is you've eroded a veto power that was inherent, that was a part of the voting power. So even though you've not changed the definition of what a vote means, you've functionally eroded the vote. And I thought that was very interesting because there was a requirement to understand Kaufman, to understand the case, but you also had to understand Kaufman to realize why it wasn't the point that the case was actually decided on, but this more nuanced voting point. So I think, what do you think would have happened if the lower court decision would have been left to stand as is, where a developer can come in and they have a playbook, right? They have a playbook. They come in, they spend so many hundreds of millions of dollars in units, they get a super majority. If there's no Kaufman language, they just amend the agreement, because they can amend the agreement with the 80% to add Kaufman language so that the amended version of the declaration does have Kaufman language as amended from time to time, not just as amended. And then with the new Kaufman language, then they can change the voting rights and vote the condominium away and get everybody the hell out of there, tear the building down, and build a skyscraper, right?
Can I go now?
Yes, please.
Okay. I had to make sure you were done. Okay.
Yeah.
So I have a lot of thoughts.
Yes, please do. Tell me.
I think that it's so important, and I'm so glad that a case like this came up and is now gonna define a lot of things. It's gonna stop a lot of other developers in their tracks, because they're not gonna be able. They're gonna see that this is not gonna turn out in their favor. They're gonna try and if we were to allow this, all these old condos would be taken over, and the developer would just have to get majority, just enough, and then they'd be able to get all of these people out of their condos. All these poor, sad people that just want to retire by the beach. They just want to retire.
What happened to the Florida dream, right? Where you buy your thing and you get to retire, you wait it out, and then you're good.
You're giving the big guy too much power by allowing a case like this to have just ended right there. I'm glad that the little people decided to appeal and decided to keep going, and they're still fighting. So they're still pushing. So
there's I sent you this, right? There is a hearing on March 4th, right? A special set hearing on a motion to compel, because apparently the developers they lost, but they haven't been good losers, right? I mean, look, I get it, right? You're 150 million in. The third district says you're cooked.
Oh no, they didn't just say that they were cooked. They said you're cooked, and now what you broke, you must fix.
Right, and that thing's a dilapidated building now, so now you have to spend $100 million fixing the building
to not be able to.
So maybe the developer's just bankrupt. It's not that they want to be in contempt of court. Maybe they just their play failed, and
3 years of lawsuit.
Yeah, now they have to fix the building that they wanted to tear down, to then maybe sell those units to try to recuperate in a down market when your competitors are all selling brand new units, luxury units. They
tried to then bring in the insurance of the building and say that it was a total loss. But then the insurance was like, no, this was intentional. This didn't fall under that provision that it was either a hurricane or something else. This was intentional. We're not covering you either.
Right, your little play failed.
Yes.
You were
this
sneaky
is-
peeky. You thought you were more clever than anybody else. You took a gamble and you lost.
This is actually just the biggest L of 2026 I'm coming right now.
Yes, that is a multiple figure L, and I hope it becomes a bigger story, a national story, and a cautionary tale for people who think they're gonna come in and just steamroll folks.
I think the developer might have to move into those condos at this point. I think it's
well,
not
they're
looking too good.
theirs now.
Yeah.
You know what's crazy to me is that I'm sure there would have been a price for which, you know, Miss Avila and the rest
And
of her
et al.
neighbors would have struck a bargain, right? But I think
That's why I'm glad that they didn't
right,
strike a bargain and that this continued all the way to where it is now.
right.
Because, like I said, allowing this to have moved forward is just none of us are safe if you do that.
Yeah,
You know.
yeah, 100%.
So-
So this is one of those crazy dockets where justice was extremely expensive to get, but eventually it arrived, and I'm just really happy and you know, great job to the litigants here. Let me see if I would shout out counsel to
Yeah, there was like 200 and something pleadings there. They tried to bring in the county to get them to stop, you know, giving out inspections and everything. And it turns out that they withdrew that suit because they already knew, the attorneys on this case that were defending the owners of the units already knew that their case was so strong that they just withdrew.
I'm gonna shout out Glenn H. Waldman from ATLLP.
If you want to
Jeffrey
come on,
R.
Miami, come on.
Lamb, if you want to come on and talk about the case, that'd be amazing. And I'm going to leave it at that because I'm uncertain about the rest of the people on this service list and who they represent. But it's pretty clear to me that those two fellas represented the plaintiffs, and I think they did a phenomenal job. And thank you from all the legal community for taking it through to the end. That was epic.
And thank you for the little guys. Again, for
Right.
not getting scared, not shivering in your boots, and
Right.
like staying strong, because you're fighting against, you know, like, who are you and who are these developers? I'm sure, who knows what happened behind the scenes, you know?
Exactly. So with that, I think it's been fun. It's been another little journey. I hope you guys enjoyed the little bit of case interpretation there that we did. And I hope you learned a little bit about perhaps how you can avoid issues with your tenants. And with that, we'll be back next time. Bye-bye now.